Virtual Utah Court of Appeals. I note that counsel are present, and it appears that you're each ready to go. Let me just review some of our new ground rules in the event that you haven't yet made an appearance in this forum. You can see that Ms. Collins has just pushed at the clock, and it appears that you have reserved 5 minutes.
Kate, maybe, I'm sorry, Judge Appleby, would you ask everyone to mute their mics?
Okay.
I'm getting a lot of feedback. I'm not sure if that's why. So.
Got it. So if you're not speaking, one rule is to mute your microphone. It helps reduce the feedback. I think everybody can see the clock that Ms. Collins has posted. It appears that 5 minutes have been reserved for rebuttal. Is that correct? All right.
Yes, it is, Your Honor.
All right, thank you. The other thing that we're requesting that counsel do is, in just a minute when we get going, if it's not your turn to speak, please take your camera off. It helps to avoid distraction for us. It also preserves bandwidth. So you'll be able to hear what's going on and see us, but we won't be seeing you. The judges will try to assist you in knowing that a question is coming by raising their hands and unmuting their microphones. It's a little bit cumbersome, and we're being a little bit more flexible in the amount of time that we're allowing for arguments to give that opportunity. Does anybody have any questions for me before we get going? All right, and then as usual, just please state your appearance anytime you're talking so that we'll know who's speaking. All right, are you ready to proceed, Ms. Pena?
Just to clarify, Judge Appleby, I am using Marina Pena's computer, so the name comes up as Marina, but I'm actually Monica Mayo. I'll introduce myself here.
I'm so sorry. All right.
No, that's fine. I have to say, I thought this
is not the first time this has happened with attorneys using other people's.
Okay. Okay. All right. No, I have to say, I thought this format would be slightly less terrifying, but turns out it's really not.
No.
All right. May it please the court and counsel, Monica Mayo on behalf of criminal appellant J.A.M. Also present today is my co-counsel, Marina Pena, although she's obviously remaining off camera. Your Honors, I noticed the timer has not, okay, there we go. Your Honors, the essence of this case is this. J.A.M. is guilty of an unlawful detention. We concede that. What the government didn't prove is that during the course of that unlawful detention, that he acted with the intent to commit a sexual offense. The juvenile court erred in concluding that it did. J.A.M. is not guilty of aggravated kidnapping, which will make him eligible for the kidnapping and sex offender registry. As I reread the briefs in preparation for this argument,
this is a quick question. Isn't his apparent sexual arousal some evidence, at least by inference, of intent?
No, and I'll tell you why. That's one of the findings. I wanted to clarify, because the briefing I thought got a little convoluted, are the credibility finding and the finding that his penis was actually out of his pants. The victim was pretty consistent that when she walked out of the bathroom, she noticed in the moment, which I think that's all happened very quickly, she noticed what she recognized to be a bump, a penis, that she recognized just from common knowledge of being a teenager, being somewhat sexually active. She was consistent that she saw a bump, a bulge, an outline, the shape. What she hedged on and where there's not consistent evidence is initially she said when she came out of the bathroom, she saw that it was out. Later, during cross-examination, she admitted that it could have been under both his pants and his shirt. We know that he was completely covered. He was not exposed. So I think, Your Honor, you're correct that if we had, and I'm sorry for all the language, but if we had an exposed erect penis, I would not be making this argument. But when you're talking about proving that someone intended to commit a grievous sexual offense based on a witness who has credibility issues based on her testimony that she saw what she believed to be the bump of his penis under his shirt and maybe under his pants. That, to me, creates sort of a slippery slope for boys and men. And so to answer your question, I've gotten long-winded here, but I think had there been clear evidence of an erection, we'd have a different story. But I want to also point out that the state mentions, this juvenile didn't use correct terminology, and she really was describing an erection. I've worked with juveniles for a very long time, and if they know what that is, and they will use some colloquial term that's appropriate for a juvenile, there would have been some indication from her that what she saw was an erection. And notably, the court did not include that. We have to assume that she did not put that word in her findings for a reason. There was not credible evidence that his penis was erect. Yes.
So I'm a little confused, I guess, now in terms of exactly what it is you're challenging in terms of the finding. A minute ago, you said you were challenging the credibility finding, and then the finding in I guess it's paragraph 2 of on page 162 that the penis was out of the pants. Now it looks like it sounded to me like you were challenging the finding that there was sexual arousal. So are you challenging that too?
Well, I mean, our overall argument is that there was not intent to show there wasn't evidence of sexual arousal to show intent. I was just more clarifying from Judge Appleby's question that that had there been an erection, it would be a much different outcome. We're still just challenging the finding that it was out of the pants, because I think that lends itself more to a finding of intent. Not necessarily, but that finding was against the clear weight of the evidence. The victim testified one way and then changed her mind. All right. In terms of credibility, we concede that the inherent improbability argument was not preserved. But this is a sufficiency argument. When they're tried to bench trials, they don't have to be preserved, but we would argue that the credibility finding is preserved anyway. Counsel's in a tough position with sexual assault victims or alleged sexual assault victims, particularly in the Me Too era, trying to be sensitive. So trial counsel, in my opinion, was trying to do everything she could to point out this victim's credibility problems without actually coming out and saying, this victim appears to be telling not the truth. KG misrepresented the truth about what happened on the 3rd floor. There is just no question about that. Very rarely as a defense attorney do you have a video that shows a victim telling one story on the stand and a video that shows the opposite. And the court was kind and did not come out and say, I don't believe you, but implicitly the court did, because she rejected that story altogether and said she could not find that it was adverse. She could not find that it was non-consensual. She did acknowledge, she sort of gave short shrift to the fact that her head turned at one point or the other. But if you've watched the video at any length, it is clear that KG's story about this being not consensual, or her having to push him away to get up, none of that was true. And then what we have is then the court inserting the word credible into one finding without any explanation about how you can watch a victim clearly tell a story that is not all true, and then relay a story that happened 20 minutes later, and find her totally credible without any sort of explanation about why you found her credible. And as an appellate, particularly defender, credibility findings are obviously very challenging, and they should be for a reason, because of the deference we give lower courts. But when a trial attorney comes to me and says, gosh, this witness has all sorts of credibility problems, and this is a straightforward credibility issue, the first thing I do is turn to the court's order and say, and I look to see if the word credibility appears. And if the word credibility appears, I know it's going to be nearly impossible to get a finding set aside. Yes.
Was it incumbent, though, on defense counsel to ask the court for additional findings on that if counsel thought they were needed in order to preserve for our review?
That's a good question. You know, findings in juvenile court are unusual because for most cases, they aren't required to make any findings. I think in cases where with this judge, she's particularly thorough, and I think she knew that this was a close case and this might go up on appeal, so she made a very thorough. But oftentimes we get minutes, and I mean, the juvenile court is not obligated to make findings in most cases. So that's a good question. I haven't really thought about that. So I know that's not a particularly satisfying answer, but I don't know that she had a duty to make a continuing objection, for lack of a better term.
Okay.
We think that the credibility finding is against the clear weight of the evidence, and at the very least, it colors the rest of the case. I mean, we have someone who, I guess how I would explain it is I suspect that if a jury heard this case and it wasn't tried to a judge who's balancing all these competing interests with rehabilitation, does this person need help in a close call, not in any nefarious way or deliberately, do we err on the side of let's get this kid services? I think if a jury had heard this case and had seen the victim tell one story and then a video that showed something totally different, I think a jury might have had a very hard time believing the story that came next. So we are challenging the credibility. Yes.
Was she cross-examined on the video? I mean, was she asked to detail why it was that what you're describing as your perception of the video doesn't seem to match up with her testimony? And what did she say?
She was cross-examined extensively about this, and she stuck with her story. At one point, the trial counsel pointed out, now, so here you're putting your arms around him. And her response to that was, I was pushing him away. And counsel said, so you were holding him to you and pushing him away? And she responded, yes. She stuck with her story. Counsel did a very good job of pointing out all of the discrepancies. Look here, are you scratching his back? No, I'm not. Are you tickling him here? No, I'm not. Are you laughing? I mean, just in complete direct contradiction to what the video showed. So yes, she was cross-examined about that. I'm not sure that I have time to get into my next piece. Maybe I will submit right now and I'll reserve some time for rebuttal, unless there are questions, of course.
Okay, thank you.
Thanks.
May it please the court, Nathan Jack on behalf of the state. This court should not disturb the juvenile court's credibility determination of the victim. Appellant hasn't identified anything that the juvenile court should have considered but didn't consider in making its credibility determination. Instead, it points really exclusively to a surveillance video, a very grainy video that is difficult to see exactly what's going on. The juvenile court
But do you dispute counsel's very careful minute by minute and second by second characterizations of what was going on in the video?
I do. I think counsel really disregards a lot of the aggression that the appellant showed through the video with pushing the victim down, pinning the victim's wrists against the ground. There were things like that the victim or that counsel just overlooks. But the trial court, the juvenile court watched that video and recognized maybe there were some minor inconsistencies in what the victim testified and what the video showed. And yet, in spite of that, the juvenile court found that victim was still credible. And it's difficult for this court, looking at a cold transcript, to find that credibility determination was against the weight of the evidence, when so much of the evidence about credibility is something that we can't get from a cold transcript. We can't look at the victim's demeanor, at the body language, at the tone. And those are all very important factors that only the juvenile court had access to. And that's why we have so much deference to the fact finder. We really only disturb a credibility determination in a very, very narrow circumstance, inherent improbability, something that counsel has acknowledged was not argued below. And the Supreme Court, in a recent opinion, Taylorville City versus Mitchell, talked about preservation is important for the dignity of the lower court, that we should hesitate to reversed the lower court on a ground that was not argued to it. The juvenile court was never made aware that that J.A.M would argue on appeal that the credibility determination was wrong because it was inherently improbable. And out of dignity to the lower court, this court should restrain from reversing on that ground. Given that, there really isn't any way in which this court can disturb the credibility determination of the juvenile court that the victim was credible. And given that, there was sufficient evidence to support the aggravated kidnapping charge. Victim testified that J.A.M's genitals were out. She described it in a couple different ways, but she did say that his genitals were out. She could see a bump. She could see the outline of his penis.
But didn't she also say it's possible that that it was under both layers of clothing?
She did acknowledge that possibility, but again, that doesn't mean that the finding that his penis was out is against the clear weight of the evidence. Acknowledging a possibility, we don't need 100% proof for a conviction. We just need beyond a reasonable doubt. And so acknowledging a possibility doesn't somehow make that finding against the clear weight of the evidence. Because of that, because of victim's testimony that his penis was out, because of the activity that we have on the third floor, there was sufficient evidence that J.A.M acted with the requisite sexual intent when he attempted to pull a victim into the bathroom and even at one point dragged her by her feet in an attempt to get her into the bathroom.
Let me just go back to the question Judge Appleby asked. I mean, if in fact the witness herself, the only one who testified that his penis was out, herself had doubt about whether that was true, is it appropriate for the court to find beyond a reasonable doubt that that fact exists?
Absolutely. There's a difference between a doubt and reasonable doubt. Again, we don't require 100% certainty. There are many cases where victims could acknowledge, a remote possibility that something wasn't what they saw. But again, acknowledging that remote possibility doesn't make it so that you can't find the beyond a reasonable doubt. And again,
does the need to describe that as a remote possibility? I mean, was her testimony such that she said, well, of course anything's possible, or was her testimony more akin to, well, no, that's possible, that's true, it could have been covered? I mean, I think that there may be a degree of doubt that her testimony evidences, right? And so I'm just curious, in this case, was her testimony more akin to, I suppose anything's possible, or was it more akin to, yeah, that's equally possible as well?
I don't think it was recognizing that it was equally possible. It was more of the remote possibility. She recognized that she couldn't see the top of his pants. And so there is that remote possibility that somehow she could see the outline of a penis through both the pants and the shirts. But I think the fact alone that she could see that bump and that it was more pronounced there on the first floor in a dimly lit hallway than it was on the third floor after 10 minutes of making out is highly suggestive that it was outside of his pants, and that you would not be able to see that through both layers of clothing. And I think even, yes.
If we, hypothetically, I'm just throwing out a hypothetical. I'm not saying this is where I'm at or anything, but hypothetically, if we were to determine that the finding that the penis was out of the pants was not supported by evidence, could you still prevail in this case?
Absolutely. We have more than just the penis being out. The fact that there was a bump shows that there was sexual arousal. And then you combine that with the sexual activity that happened on the third floor with the making out. And it was more than just kissing. J.A.M, tried to, he grabbed victim's buttocks. He tried to place his head on victim's chest several times. And this was a 10-minute extended period that they had. And then it's just a short time from that he's trying to drag her into the bathroom by her feet. I think that's all suggestive, even without the penis being out of the pants, that he was doing that with intent to take indecent liberties, for example, or commit some other sexual offense. Given the juvenile court's credibility determination, and given that this court, it would be difficult for this court to disturb that credibility determination. There was sufficient evidence to support the conviction here. And if there are no other questions, I urge this court to affirm.
Thank you, Mr. Jack. Ms. Mayo?
Okay, I want to respond to several things. First of all, we conceded at the beginning of the argument that inherent improbability was not preserved, but the other questions about victims' credibility were preserved through impeachment. It was again argued during closing argument. And again, it's a sufficiency finding, so it's not necessary in a bench trial to even preserve sufficiency findings. This isn't a cold record. You have the video. You can view this just as the trial court did. So it's not necessarily a cold record. And I understand the whole concept of an appellate court getting a record and not being able to make credibility determinations like trial court judge can. I fully understand that. But you have the video too.
The problem, as I see it, though, is that the video is for a period that is different from the period of the charged crime.
Sure. Yes. It just goes to her credibility and the court's rejection of her story, and the judge's conclusion that what happened on the third floor was not non-consensual. And I took issue with it in the brief, counsel's characterization of J.A.M. as aggressive. I watched that video. Yes, there are times when he holds her wrists, but I pointed out in our reply brief that every time that happens, the next thing she does is smile or laugh or grab his back. So I don't think that's fair to characterize his actions as aggressive. Let's see. We've also conceded there was an unlawful detention. Counsel talked about her being dragged into the bathroom, but she actually never made it into the bathroom, even despite 10 minutes of dragging. Our position, obviously, is that if the victim testified, when I first came out, I saw it out. And then later, and I found the testimony in the record, it's on page 46 of the trial transcript, and it says, how do you know? She's talking about his penis, because you could see like the bump. Could you see the top of his pants? No. Okay, so you don't know if it was under his pants or not. Maybe you could see it through both. Yes. And also, it's important to point out that the court made a finding that it could not find beyond a reasonable doubt that the pants were unzipped, that they were down. The victim testified they were on and up. So it makes the story that it's out of the pants even less likely. And I disagree completely with the state that bulge is a sign of sexual arousal. And I think that's a very dangerous concept, depending on what they're wearing, sweatpants, exercise shorts. I mean, that's a bothersome idea to me.
A person's arousal might or might not be covered by clothing, right?
Right. He was clearly covered. He was not exposing himself. But she never described it as that. Again, we go back to what she used in the language the court used. She described it as a bump. And she described it as a bump. Judge Harris, I wanted to address your hypo. I don't think the state still prevails. And the reason I don't think the state still prevails is because what happened on the third floor was consensual kissing, consensual sexual activity. What happened after that is they wandered around the school for 20 minutes, and the victim herself testified nothing was said. They didn't continue holding hands. There was no kissing. There was a break in the activity. It would be a different case if they had been in the downstairs hallway kissing, and then she goes into the bathroom and he tries to pull her back in. But we have a break in time with nothing else sexual happening in that time frame. And so I don't know. I mean, the court even in its findings said, oh, what happened on the third floor doesn't really matter. But then when it got to the intent finding, all of a sudden it did. And this is not something I briefed, but I looked at some of the sexual intent cases, Watkins, Toller, some of the other sexual intent cases. And sexual intent is most typically determined sort of contemporaneously. And I think sort of in closing, what I'd like to have you think about is think about two 17-year-old kids at a party. right? And they are in a corner and they're making out and it's consensual and they're having fun. They stop and they decide to walk around the party together. They're wandering around for 20 minutes or so and they end up in a hallway. Girl goes into the bathroom and when she comes out, he tries to pull her into the bathroom. Is it enough if that victim then gets up and testifies, before he pulled me into the bathroom, I saw a bump under his clothing. I saw an outline. It was visible. Is that enough to establish an aggravating factor telling a child you are a sex offender based on a victim who has credibility concerns too? Is that enough? And I would argue that seems to be a slippery slope for men and boys. I think it's the wrong outcome, and I think it's the wrong outcome in this case. So we agree he's guilty of an unlawful detention. We think the aggravating factor was not proven, and we would ask the court to reverse the aggravated kidnapping charge and remand with instructions to enter the unlawful detention charge. And my time is up.
Thank you, counsel. It doesn't appear that the other judges have questions. So what I will say is that we will take this under advisement and get you a written decision as soon as we can. We appreciate your patience in appearing in this format. Mr. Jack, we appreciate you as well, and wish you both a good day, and we'll get back to you as soon as we can. Okay?
Thank you.
Thank you.